Good morning, government students. Today we're going to talk about the amendment process to the U.S. Constitution. So this is obviously the way that we change the Constitution, and also a great example of federalism, how both the national government, Congress specifically, and the states share power. All right, so great example, like I said, of federalism. So let's take a look. So amending the Constitution. All right. So this is originally set up. The process is listed specifically in the Constitution, and that is, there's a couple of different methods for doing so. Right. But the main one, which 26 of the 27 amendments have been passed and ratified this way, is the one that you see going straight across here. And that is 2/3 of Congress, right? So both the House and the Senate together, both 2/3 of Congress and 3/4 of the states must agree or pass the constitutional amendment. It's called passing a constitutional amendment when it's going through Congress, and it's called ratification, or basically the confirmation of the states that that solidifies or ingrains it directly into the Constitution. All right, so the main other two ways in which you can also pass an amendment is through, again, another 2/3 of Congress, or instead of the state legislatures, like here in South Carolina, we have the State House in Columbia. That's the state legislature who would then vote. 3/4 of the members of the state legislature would have to agree, both the House and the Senate. Or in special circumstances, they can call a state constitutional convention and convene for the purposes of hearing the constitutional amendment. Again, this has only happened one time, so the one that's seen in red has only happened one time right here going across, and that was for the 18th Amendment. In the that basically prohibited alcohol, started the Prohibition period, which was also outlawed in the 21st Amendment. So the main way in which you need to know is 2/3 of Congress and 3/4 of the states. Okay, there's also a couple other ways in which you can do it that's seen here by having a national convention called by the states instead of Congress, but that's never really occurred. So we don't really usually talk about that one as much. Okay, but what this does is that this amendment process allows for flexibility. The founding fathers noted, especially after witnessing the problems in the Articles of Confederation and the lack of being able to change the articles, that they needed to have flexibility with this new Constitution. Because times are going to change and the needs of the country are going to need to change. And if it's something that is important in terms of a need for a change, then it is an attainable goal, right? So 2/3 of Congress, 3/4 of the states, that's a high bar, right? We don't want to necessarily make it easy to amend the Constitution because that's actually kind of dangerous, right? You can make some, pretty drastic changes without a large majority of the citizens agreeing to it. And so for that reason, they did set a high bar, but again, it's not as high as the Articles. The Articles of Confederation required to be unanimous among all states, and that is too high of a bar, because it allows for, it's very difficult, to get that passed, and therefore they could not adapt with the unforeseen problems of the time and quickly collapsed. So they were trying to prevent this from happening again with the new Constitution. All right, so the first time we started amending the Constitution was pretty much immediately following its ratification of the Constitution in 1791. We see the first, amendments to the Constitution passed. The first 10 are called the Bill of Rights, and these were specifically passed in response to anti-federalist protests. Remember, anti-federalists were ones that were originally against the Constitution and this concept of the new Constitution. And one of the main complaints was that the Constitution didn't guarantee enough, in writing at least, freedoms that needed to be protected of the citizens, right? So the anti-federalists were afraid of this new powerful federal government. And so in order to make sure that they are protected, they wanted in writing and ingrained in the Constitution forever, these protections. So, this Bill of Rights was passed very early on, right, in the first couple of years of the Constitution. And this was originally seen as unnecessary by James Madison, who is the father of the Constitution, right? He's the main author, the actual framework and ideas behind it, of course, with help from other founding fathers like Hamilton and others. But he agreed to do this because the Anti-Federalists were so worried about not having these Bill of Rights included that they were unwilling to even ratify the Constitution. So this is a way to appease these Anti-Federalists and get those votes that they needed to ratify the Constitution and get rid of the articles. So that's why Madison had a change of heart here, even though he felt it was unnecessary, because in his idea or his belief, you didn't need these in writing, because the way the Constitution works is that Congress and other parts of the government only have the powers that are specifically written into the Constitution. All right. And so if things like the ability of Congress to take away your free speech is not written in the Constitution, then they can't do it. Right. And so that was his logic and thinking behind it. Well, Anti-Federalists were still unconvinced. They had been burned by the king in England, right, and others, and seen how those rights can easily be taken away if there's not a written constitution. They don't have a written constitution in England, so they wanted it written down. That's why we got the Bill of Rights. So in 228 years, actually 229 now, we only have 27 total amendments that have been passed and ratified and added to the Constitution. And 2 of those have been canceled out. All right. The 18th and 21st Amendment cancel each other out, the prohibition of alcohol. So really 25 amendments. And again, those first 10 were passed almost immediately following the ratification of the Constitution. So really only 15 changes, major changes since the early years of the Constitution. All right. Even though, we've tried, right? There's been several proposed amendments, thousands actually. 33 have been passed by Congress, but there were 5 of those that did not get ratified by the states. Okay, so it is fairly difficult. All right, so let's see. Here we go. Here are the amendments to the Constitution. You might want to pause the video for a minute. This is a great little tool to kind of quickly see what's going on in each one. Has a little bit of a description there of each amendment. So go ahead and pause your video and kind of peruse this for a minute before I go into more detail. All right. So let's talk about some of these amendments. I'm going to hit the highlights of these real quick. I'm, of course, not going to go over every aspect. There are some great study tools out there that I've given you already, and plenty of other resources. Amendment number 1 is 5 amendments really wrapped up into one. It's 5 freedoms. They are the freedom of assembly, or right to assemble peacefully, amongst fellow citizens. There's the freedom of speech, right? The government cannot, create laws that prevent your freedom to speak freely. Freedom of religion. This is actually more specific to both the act of, performing or the ritual of your religion, and also that the, government does not, establish a national religion or prevent, religions from operating. We also see the freedom of the press, right? As in media, journalists, things like that, right? From their ability to operate, and the freedom to petition or ask the government to hear changes. Okay, and one thing I want you to notice, especially after seeing this First Amendment, is that what they are doing are specifically, especially in the Bill of Rights, right? We're still in the Bill of Rights, the first 10 amendments. They are telling Congress and the federal government in general that they cannot do these things, right? These are denied powers, things that Congress cannot do, and basically what they're saying is they cannot make a law that takes away free speech or establishes a national religion or infringes upon the press. Okay. Now we'll talk about it. These are not absolute. There are types of speech that are prohibited. There are actions of religion that are prohibited and things like that. But we'll get into those court cases later. Second Amendment, right to bear arms, right to own firearms and other types of, weaponry to protect yourself and your home. I'm only going to hit the highlighted ones, the ones that come up the most often in the AP exam, and you can read through the other amendments later at your own, your own pace. Fourth Amendment. This deals with search and seizure, as in the police officers and the rights in which you have when being searched, and the seizure of your property. Generally speaking, it means that they need to have probable cause and usually obtain a warrant before they can search and seize any of your property. Okay. Fifth Amendment. This is a bunch of amendments wrapped up into one as well, right? This has to do with the rights of the criminally accused. You've been accused of a crime. Here are your rights now. All right. You have the right to a grand jury, basically a jury of your peers that, look at the evidence, decide whether or not there's enough evidence to bring you to trial, not whether you're guilty, but whether or not there's enough evidence to bring you to trial at the federal level. Double jeopardy means that you can't be tried for the same crime twice, which obviously that would be terrible to keep getting going on trial over and over again. In that sense. Self-incrimination. This is where the term pleading the fifth comes from. This is one where, if you are being asked a question that would possibly incriminate you or cause you to, lie under oath, or not force you to lie, but cause you to possibly lie under oath in order to protect yourself, you can simply, remain silent instead, right? You don't have to answer questions that may incriminate you. All right. And so this is why your lawyer usually advises you not to answer certain questions. All right. Due process means that the government has to follow the due process of law, or basically follow the rules in order to, before they can take away your life, liberty, and property. Right. So this is a very fundamental right that we have to go through a jury trial and obtain warrants and have a jury of your peers and all these stuff. Right. That's due process. Eminent domain means that the government can take your, your land or your property from you if they, deem it necessary. However, they do have to, compensate you for it, right? So if they need to build a road and that goes through, cuts through your property, they can seize that land. However, they have to give you, some type of compensation in return. Okay. All right, moving on. Amendment 6. This is, if you notice, we've gone from search and seizure to you've been accused of a crime. Now you're on trial, right? You have the right to a speedy trial in the Sixth Amendment. Can't languish in jail. Right to an impartial jury. If there is an overt bias in the area, and you have a strong reputation, they may move the trial so you can get an impartial jury. You have to be informed of your charges, why you are being, charged for the crime, and you have the right to an attorney, right? So the right to an attorney is deemed essential in our form of government. And all right, so we're moving on now to you have been convicted, all right, in the Eighth Amendment. What freedoms or protections do you still have? Eighth Amendment says no excessive bail. When you're being held, if you or let's say you're speeding, right? They don't set $1 million bail for speeding, right? Something like a little more serious would warrant that. Cruel and unusual punishment. Okay, so this is obviously open to interpretation, but basically, once you've been convicted, you are still protected from any type of cruel or unusual punishment. This most often comes up in terms of the death penalty is usually where the Eighth Amendment comes in, but it can come up in other punishments as well. Ninth Amendment is called the et cetera clause, right? So to appease the people that say wait, I should have more freedoms than what we listed already. Well, they said, well, you do, right? So you have other rights not granted in the Constitution. Okay, and this is going to be cited in several court cases later. Like, for instance, this is where you get your right to privacy. Your right to, medical procedures, including abortions, were cited in the Ninth Amendment and others. And so you have other, rights that are not necessarily mentioned in the Constitution. And then the final Bill of Rights amendment is the 10th Amendment, and basically says it's the catch-all, right? At this point, if the federal government has not taken the power, right, has not been given the power to declare war or coin money, then any power not listed in the Constitution given to the federal government is therefore reserved for the states. Or basically, if it doesn't talk about it, then that power goes to the states. For instance, they conduct elections and make election laws. They are able to develop and institute their own education systems and create marriage licenses and marriage laws, right? So those things aren't mentioned in the Constitution, therefore they are reserved for the states. All right, moving right along. Now, again, the rest of these were basically post early years of the Constitution. So now we're getting out of the Bill of Rights and into other amendments. And the next one we'll start with is not until after the Civil War, right? So it's a long period of time before we really change much of these parts of the Constitution. All right, but after the Constitution, after the Civil War, all right, we see the 13th Amendment abolished slavery. 14th Amendment came right after one. This is one of the most important amendments that we have. For a couple of reasons. Number one, it protects the equality of all citizens and makes it to where the states can't infringe upon the equal protection of those laws. All right, so no matter if you're a man, woman, it doesn't matter if you're black, white, whatever, whether your race, religion, all of these demographics, right? You cannot be discriminated based on those and provided the equal protection of the law. All right, and it also says that states must now follow the Constitution and protect those, fundamental freedoms that we just talked about that are in the Bill of Rights. Before the 14th Amendment, only the federal government had to protect things like your freedom of speech or, right to have a lawyer and things like that. But after the 14th Amendment, now all of a sudden the states have to provide those freedoms as well. All right, so that's why it's super important for two different reasons: equal protection clause and this due process to the states. States have to follow the Constitution now too. All right, and 15th Amendment guaranteed suffrage or the right to vote to all males. Notice females, not yet. That would come later here in the 19th Amendment. Not till 1919 do women have the right to vote. Also, the 16th Amendment is one that comes up often. It is the Congress has the ability now to pass direct taxes on the citizen. Before, they had to tax the states, who then had to tax the citizens. But now Congress can take an income tax, which if you work and you've seen your pay stubs, you know that Congress likes to take a nice little chunk out of your paycheck that goes towards taxes. All right. So that's where the 16th Amendment comes in. All right. And then our last set. All right. So the 22nd Amendment is the one that formally limits the president to 2 terms. Notice, it was just a accepted fact that presidents would step down after 2 terms. But when FDR, was elected to 4 terms, during the Great Depression and then World War II, they realized that, it might be setting a bad precedent that we could have a president that could serve, for life, right? And that's not something that we necessarily want in a democratic society. So they passed this 22nd Amendment that says presidents can serve no more than 2 terms, okay? 2 full terms at least. All right, 24th Amendment. Poll taxes. Okay, so one of the things that Congress and the amendment process had to do was limit as to what the states made as far as laws regarding elections. Remember, states under the 10th Amendment can make laws regarding elections, but if you pass an amendment, that supersedes the state's ability to create that law. So the 24th Amendment said that states can no longer create taxes that make you able, prevent you from voting. And this was mainly in the Jim Crow era South, which is what this was trying to prevent. 25th is going to be for the rules and succession of the president, as in if the president were to die or become disabled, who would take over and what's the process for doing so? What if it's temporary? All those things. All right, we'll talk more about that later in the year. 26th Amendment, again, this is state, the Constitution now setting what states can do in terms of election laws. And now it's saying that 18-year-olds, right, could now vote. This was coming off of the Vietnam War, where they were going off to Vietnam, an unpopular war, and the boys fighting there could not even vote yet, or make any kind of difference. So that was the main impetus there for the 26th Amendment. All right. So there are 27 amendments. The last one was passed. The 27th Amendment was passed in 1992. We haven't had one since, although we've had many suggestions for different, possible constitutional amendments, over the years, and they come up from time to time. All right. So again, constitutional amendment process, great example of federalism. Okay. Remember, 2/3 of Congress and 3/4 of the states need to ratify these.